My name's Eric Olson. I'm with the Client First Insurance Agency. It's a privilege to welcome all of you to today's educational event hosted by attorney Rob Mielek of Mielek Law. Our topic today is 50 fast facts about estate planning. And trust me, this is going to be rapid fire. Rob has a great story back in college. As the only Midwesterner on his football team, he was nicknamed Fargo for talking slow. Fast forward 20 years, and now he's known for talking fast. So buckle up. We got a little trivia for you here. So, estate planning has been around for thousands of years. Do we have any guesses which ancient civilization first recorded wills? Any guesses?
Egypt.
What was it?
Egypt.
Egypt. Got Egypt. Any others? Romans? Babylonians? Okay. Well, you got it, Jim. It is Egypt. Ancient Egypt, over 4,000 years ago, they carefully drafted wills to ensure orderly succession. And then later, Roman law formalized estate management, laying the foundation for modern estate planning. And because estate planning doesn't have to be boring, here's a couple dad jokes about estate planning, lighten the mood. Why did the estate planner cross the road? To make sure everything was properly executed. Okay, there we go. Why did the estate planner bring a ladder? To help clients reach new heights in their legacy planning. All right. Maybe some more coffee might help. Try that. At Client First, our core values guide us in everything. So I always like to highlight a couple. They're not just the words that are on the wall in our lobby when you come in. Today, number one, we love our clients and are fully committed to their well-being. So estate planning is about protecting what matters most, your family, your legacy, your peace of mind. We believe that true holistic planning is the only way to care for your financial health. That's our another one of our core values. And it's about integrating financial planning, estate planning, insurance, taxes, and your personal goals into one cohesive plan. So with experts to guide you along every step of the way, like Rob here. So the values also remind us that education is key. That's why we hold these. The more that you know, the more that you're better prepared to protect your future. So with that, I'm going to introduce Rob. Rob's a native of Hubertus, Wisconsin. He resides in Mequon with his family. He earned his law degree from Penn State, and he specializes in estate planning and elder law. Teaches classes at Moraine Park Tech College and has helped countless families preserve their assets and avoid probate. His approach is client-friendly, offering free initial consultations, flat fee pricing, and unlimited communication, because planning your legacy shouldn't come with hidden costs or stress. So if you take one thing away from today, remember, before you die, call this guy. And with that, please welcome me in introducing Rob for his presentation today.
Okay. Eric's a little thinner than I am, so I'm going to move the podium a little bit forward here, so bear with me here. All right, so Eric, thank you for that introduction. Again, just by way of a little background, my name is Rob Mielek. I'm an estate planning attorney. I've had the privilege of working in partnership with Client First for the better part of the last 12 years here. So it's been a great relationship. I'm very grateful for that opportunity. Again, today's presentation, for those of you, there's a lot of familiar faces in the audience, so you've probably heard me do a couple of these presentations. This one takes a little different format as opposed to kind of covering specific issues in a lot of depth. We're doing kind of the opposite. We're covering 50 issues to try to cover more breadth of knowledge as opposed to kind of getting into depth with things. So as Eric mentioned before, I intend to leave plenty of time for questions at the end. I'm just going to kind of try to get through these. If there is absolutely a question that you're just dying to ask, again, feel free to raise your hand, and I'll make sure I see the hand and make sure I answer the question, okay? So again, as Eric first started here, estate planning has been around forever. Dates back to 6th century Rome. That's the research I found. I did not find the 4,000 years back in Egypt. I found it there. But I can tell you the first American estate plan was recorded in 1797. So this is a subject that has been around for a while. And again, it makes sense, regardless of what kind of communities we were in, how we were living, religious arrangements. It was important for everybody to be able to leave a legacy for the next generation, and how they do that efficiently, how they do that securely. That's where estate planning comes into play, and that's what I help people do. Making sure that what you guys work hard for during your life goes to your loved ones, goes to charities that you value with as minimal cost, time, aggravation, and governmental interference as possible. Inheritance tax, okay? Wisconsin had a first inheritance tax in 1899. Again, the idea behind the inheritance tax was just like with any tax, was to try to make up shortfalls with governmental spending. I am pleased to tell you that at present, Wisconsin does not have a state inheritance tax. There's a federal inheritance tax, but the state inheritance tax was abolished in 2007, which ties into the next slide here. Again, 37 states do not have an inheritance tax. That's a good thing, okay? Only 13 of them do. However, what I would point out is the second bullet point is that does not mean all money passes tax-free. There's capital gains. There's things that we have to look at there as far as when you acquire property versus what you sell it for. And then assets that you acquire that you have not yet paid tax on. I'll give you a very basic example. I'd be willing to bet most people in this room have an IRA or a 401k, okay? What is that asset? That is what we call a pre-tax asset. To use client first language, they call it a qualified asset. They mean exactly the same thing. It is money that as we sit here, you have not paid tax on. Any money that you did not pay tax on at your death, your beneficiaries, unless they're charitable, will pay tax on that money. So just because there's not a state inheritance tax, just because you may not be subject to a federal inheritance tax, unfortunately that money does not mean that it is passed along tax-free. Because the logic is you've held on to money in IRAs and 401ks for so long, without paying tax, the government eventually says you got to pay tax on that money, okay? And we're going to talk about the federal inheritance tax right now, okay? Again, most people in this room are not going to be subject to this, okay? There is no federal estate or inheritance tax for non-married individuals if your net worth is less than $13 million, or for a married couple, $26 million. If you are over those thresholds, we need to have very specific conversations. Because again, we have to plan for the possibility that your estate would be subject to an inheritance tax at the federal level. Now, of course, like with anything, it's a common theme in my practice, laws can and do change. So obviously, as we sit here, these are the numbers that are presently in effect. You get a new administration in, you get new policies, numbers could go up or down, inflation, whatever the case is. So again, this is a snapshot moment in time. This is the reality that we know presently. That's all we can go off of. But again, I do want to mention the possibility that there is a possibility that it is going to change over time. These are just the present numbers. Wisconsin is a marital property state. I'm sure pretty much everyone in this room, especially the married folks in this room, have heard that phrase before, okay? Again, if there is not a pre or a post-nuptial agreement, there is a presumption that all assets will be considered marital. Pre and post-nuptial agreements are ways to avoid having be subject to marital property laws. You can decide prior to the marriage or even after the marriage that, hey, we want these assets separate. The only other way to do that is to have it all be joint. There is one exception to that, and that is inherited property. So if you have a husband and wife inherits property, there is the possibility that will be considered separate non-marital property. However, it depends on what that money is used for. For instance, spouse receives money through an inheritance. What are they going to do with that money? Well, broadly speaking, they're going to do one of two things. They're going to put it in an existing account, or they're going to create a new account. If that new account is a joint account, it's now all considered marital. But even if it's in a separate account, okay, separate account in place, and some of that money is used for common household expenses, it is now all deemed to be marital, okay? So it's very important that we understand that, particularly in the case of blended families, which we'll get to in a little bit here, okay? It's important to understand the ramifications of Wisconsin marital property law and to perhaps create documents to maintain the separateness of the property, because I do run into that all the time. Second marriages, spouses pass away, people get divorced, whatever the case is, and they say, well, you know what, I want my assets going to my kids and his assets going to his kids, whatever the case is. And unfortunately, unless we have a pre or post-nuptial agreement, Wisconsin marital property law doesn't make that distinction, okay? And again, we talked about this here. having children who are not common to the marriage. A surviving spouse does not automatically receive that. I'll tell you a quick story. I do some work for an accountant in Port Washington, and I got a call from her office saying, I have a widow in my office who is in tears now. Can you help her? I said, what's the situation? She said she was married, okay? She was married to this man for 25 years. It was his second marriage. It was her first, okay? They were living in a home that was just in husband's name. So even though they've been married for 25 years, never added second wife to the home. Husband dies. No estate plan whatsoever. I had to explain that under Wisconsin marital property law, that second spouse does not get everything because there were children from a previous marriage. So that's an exception as well. Spouse is entitled to their marital half, but then the children from the relationship, previous relationship, are entitled to the rest. Okay? Again, this can only be remedied by having an estate plan. If they had created an estate plan, whether a will or a trust for this matter, it could have specified all assets passed to my spouse. The bigger issue with this particular case that I just described was that father or husband only had one child from a previous relationship, but that daughter was estranged from him for 13 years. So a daughter from whom he was estranged is now getting a large portion of the estate because they did not have proper estate planning in place. So again, it is very important that you consult with an estate planning attorney if you're choosing, if you're in a blended family, to make sure you understand your rights and responsibilities. Number 7. Spouses do not automatically have POA rights. Let's talk about POA. Again, I'm sure most people in the room know this. POA stands for power of attorney. There are 2 types of powers of attorney: healthcare and financial. Okay? What I'm saying is this. Most people, again, tying back to the previous slide of marital property, just automatically assume that spouses have those rights. They don't. I'll give you an example. I drive to this seminar today. Let's say that I was in a horrific car accident. I was taken to the hospital. I was in a coma. If I did not have a healthcare power of attorney in place, not only can my wife not make medical decisions for me, she can't even receive any information regarding my care, my injury, my prognosis, because sharing that information without my consent, which I can't give if I'm in a coma, violates my HIPAA rights. Okay? So spouses do not automatically have that right. That applies to every single person in this room. If you are married and you do not have health care and financial powers of attorney, you cannot do anything for an incapacitated spouse. Okay? So that's important. We got to make sure that we have the appropriate estate planning documents in place to allow for that to occur. That also could be the case, as we get older, maybe the car accident isn't the issue, but maybe Alzheimer's or dementia is. Let's say one spouse starts to decline, starts to have dementia. We have really 2 problems there. One, the one I just mentioned, healthy spouse can't make decisions, but maybe the more important one is if the unhealthy spouse, the one who's experiencing the dementia, deteriorates to the point where he or she doesn't have the capacity to sign documents, then we don't have any documents in place. We don't even have the ability to create a power of attorney if we don't have capacity. Okay? Again, tying into powers of attorney. We talked about spouses. Now I'm going to talk about people who have children over the age of 18. Okay? I'm going to give you a specific example here. I have 2 sons, 2 boys, 15 and 13. So we're getting close to 18, right? The idea is this. If we fast forward to February 6th, 2028, okay, that is my oldest son's 18th birthday. He will still be a senior in high school. He will still be living in our home. He will still be on our health insurance. He drives to school that day. He's in that horrible car accident. Even though, again, senior in high school, living at home, on my health insurance, he gets in that accident. He can't make decisions. We as parents, again, can't make decisions, can't receive any information regarding care, prognosis, or injuries. So again, that's a very important thing for people to be aware of. And again, based on the demographics in this room, maybe we don't have many people who have children between the ages of 18 and 22. But perhaps we have grandchildren between the ages of 18 and 22. And it's important that their parents know that if we don't have powers of attorney for that newly minted 18-year-old, we as parents cannot make those decisions. And again, that's a fact that a lot of people just aren't aware of. That's pretty common in my industry. There's just so much misinformation. If I polled 100 people at Walmart who had children between the ages of 18 and 21 and I explained that to them, I'd say 98% would say, well, of course we can make decisions. We're the parents. Why couldn't we make those decisions? They'd be 100% wrong. So again, having full information to make sure that we understand the consequences of not creating these documents. Number 9, powers of attorney can be updated and revoked. Again, life circumstances change. Again, when I do seminars, I oftentimes talk about 3 Ds and a B. Death, divorce, disability, birth. These are 4 common life events that may cause you to want to reconsider who you have in charge of making those decisions. Go back to the example of the 18-year-old. The average 18-year-old who has powers of attorney in place is probably going to pick their parents to serve in that position. Well, down the road, maybe they get a significant other, girlfriend, boyfriend, get married. They probably want their spouse taking over. So again, these documents are not set in stone. We have the ability and we should make changes based upon life preferences. And again, at my firm, I don't charge for revisions. So if there are those revisions, those changes are completed on a complimentary basis. Okay? Digital property. This is a big one. Again, as cryptocurrency, Bitcoin, things like that come more prevalent, Wisconsin needed to adapt and created a digital property act that, again, allows powers of attorney, executors, and trustees to be able to deal with that after death. The problem comes into play, and I had this come up a couple of days ago in my own practice, where somebody had Bitcoin, and Bitcoin does not allow you to list a trust as a beneficiary on those assets, okay? This is something you need to know, because again, these businesses are international. They have different rules and regulations. You got to play by their rules. If you don't like their rules, you either have to adapt or find another entity in which to invest. Because again, my advice to clients is we should list the trust as beneficiary. Bitcoin doesn't let you do that. So again, there's workarounds, but it may not be the exact way you want to do it. So again, it's important to talk to an attorney, understand what your options are. Fact number 11, powers of attorney are tied to state laws, okay? Here's the issue there. I get a lot of clients who decide to move into or move out of Wisconsin. Powers of attorney almost always need to be adapted based upon state of residency. Because if anybody in here, certainly any of my clients in here, have powers of attorney, there are multiple references to state statutes. As we can all appreciate, 50 different states, 50 different sets of laws. Wisconsin statutes are not going to apply in any of the other 49 states. However, if you are traveling, okay, then it's different because you are not establishing residency in that state. I can give you a personal example of that. About 7 years ago, I was in Pennsylvania, ended up having pancreatitis. I was in an ICU for 6 days, okay? I had a power of attorney in place. Wisconsin power of attorney, they were able to honor it, no problems. But again, if we change residency, it's important to talk to an attorney in that state, find out what their laws are. But in my experience, powers of attorney always need to be adjusted after we move and establish residency in a different state. Snowbirds. Snowbirds can keep their estate plans. Again, there's a difference between powers of attorney and the estate plan. The estate plan does not have specific references to state statutes. So you could be a Arizona resident and have a Wisconsin trust in place. You can do that. There is only one exception, okay? And that is Florida, okay? I don't know why it is, but it's Florida, okay? As you can probably appreciate, as we're at 31 degrees in mid-November here, a lot of people get tired of the cold weather. They want to relocate. Florida is a common place for people to do so. And I've had dozens of clients in my experience start out as Wisconsin residents and move to Florida. Well, I've heard from multiple Florida attorneys that for whatever reason, Florida laws do not honor out-of-state trusts. It's probably a way to insulate that state and get more business for the attorneys that do the work there, okay? But pretty much every other state that I've encountered, they do accept out-of-state powers of attorney. And it's one of those things that it's not that they don't accept it in Florida, it's just that it's easier and ultimately less time-consuming if you upgrade it to a Florida trust. Again, the key things there as far as the second bullet point is establishing residency, okay? I'm a Wisconsin resident. If I had the money and I wanted to, I could buy real estate in all 49 other states. It doesn't make me a resident. It just means I own real estate in other states. So again, if you establish residency, that's a different thing. But if you're purchasing real estate, what I encourage people to do and what I will do is I will put you in touch with an estate planning attorney in that area and rely on him or her to say, okay, I have a client who has a Wisconsin residency, but now owns real estate in Washington, let's say, okay? And now we need to find a Washington attorney who can guide my client to say, all right, under Washington law, this is what we ought to do. And I can guide them accordingly with that and put them in their hands. Again, I can't do it directly because I'm not licensed in Washington. I'm only licensed in Wisconsin. So if you're a snowbird, talk to your estate planning attorney, figure out what your options are as it relates to both establishing residency and or purchasing real estate. Beneficiary designations, okay? And again, I'm going to speak in broad terms. Every single person in this room falls into one of three groups. And perhaps after this presentation, you'll switch groups. But as of now, we are all in one of three groups. Group 1, I have no estate plan at all. I have neither a will nor a trust. Group 2, I have a will-based estate plan. Group 3, I have a trust-based estate plan. I don't care which group you ultimately end up in, we have to have beneficiaries on every single asset that we can. That includes, but is not limited to, real estate, checking, savings, CDs, money market accounts, IRAs, 401ks, life insurance. We need to have beneficiaries. The problem is that depending on which of those 3 groups you fall into, the beneficiary is going to be different. So what I always tell my clients, the choice of estate plan drives the train. Decide which of those 3 groups you're going to be in, and then we can list beneficiaries accordingly. But beneficiary designations are always going to supersede what is in a will or a trust. Okay? I'll give you an example. A lot of my clients who have charitable intent will decide to list a charity or charities as beneficiaries under an IRA or a 401k. They do so for tax reasons. That's a very common strategy that myself and Client First engage in. The estate plan itself may say it's all divided between the children, but that particular asset, at least in whole or in part, is going to charities. So again, the beneficiary designation is always going to supersede what's in an estate plan. Bank assets can have beneficiaries, but most do not, okay? Again, excluding my own clients in here, excluding anybody who has a trust-based plan through another attorney, I'd be willing to bet, based on statistics, once you exclude those 2 groups, less than a third of everyone else in this room has beneficiary designations on their banking accounts. Because when you go to a bank, you're not thinking about that. When you choose a bank, you're looking at where can I get the best interest rate? Where can I get the free checking? Whatever the case is. Where do I get a free ATM card? You're not thinking about beneficiary designation. The banks are not great at asking for those. So my advice to you again is this. If as you sit here today, you have bank accounts that do not have beneficiaries, go to the bank in very short order and make sure they have beneficiaries. If it's a trust, you make sure you list your trust. If you don't have a trust, make sure you list your human beneficiaries. The problem there is those can be limited, okay? I'll give you an example. My grandmother is still alive. She just celebrated her 90th birthday on Halloween. My grandmother had 5 sons, my dad, of course, being one of them, okay? When I set up her estate plan, she, of course, wanted it divided 1/5 to each boy, right? Now, as fate turned out, 2 of her sons have already predeceased her. So that kind of ties into my next slide as well. But the point is, for this, is that when you have bank assets, they don't let assets go down a generation. So in other words, my Uncle Dave, who passed away, has 2 kids. What she can't do is say at the bank, if Uncle Dave dies, it goes to his 2 children. It's just the way it is, out as far as how many people survive at that level. Of the 5 children, that's how it gets divided. And that's not what most people want. Most people would say, if my adult child who has children of his or her own dies before me, I want their share going to their children. Again, with bank assets, that can only be accomplished with a trust. Okay, and we're going to talk about wills and trusts as we go forward here, because some of the next slides kind of implicate that. Again, difference between per capita and per stirpes. I'm sure everyone in this room has heard the phrase per capita. It's Latin for by the head. That's what I just described to you. You have 5 children, boom, 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 boom. We divide it out. However many of them survive, that's how many ways it gets divided. Per stirpes, on the other hand, is Latin for along the bloodline. So if a child predeceases, their share goes to their children, which is what most people want. Again, it is very important to understand how your beneficiary designations are listed to know whether it is per capita or per stirpes. Tying in the number 17, estate plans do not change beneficiary designations. Okay? The idea is this. It kind of ties into what I said before. If I create an estate plan, let's just say, or forget that for a second, let's say I created a beneficiary designation on an IRA account that I had before son 1 was born, but after son 2 was born. So the idea there would be I'd list my 1 son as the beneficiary after my wife. Well, time goes on, I have a 2nd son, but I never update my beneficiary designation, even though I have a will or a trust that says divided 50-50 between my 2 boys, the beneficiary designation is going to supersede. So it is very important to make sure beneficiary designations stay up to date. One example there would be people who are in the spot where they have adult children, but they do not yet have grandchildren. Once those grandchildren are born, it's important to make sure they are added on as beneficiaries. A lot of assets can't have beneficiaries. Okay, I just mentioned 2 minutes ago about the importance of making sure every asset that can have a beneficiary does have a beneficiary. Well, here are some common examples of assets that don't. Vehicles, jewelry, appliances, tools, furniture, boats, firearms. For a lot of people in this room, the aggregate of those assets, the total of those assets likely exceeds $50,000. So for those of you who have, or who are in Group 1 or Group 2, remember, no estate plan, will-based estate plan. If you have more than $50,000 worth of those assets, the estate's still going to probate anyway. Okay, so again, it's very important to know that for most people, trust-based planning is going to be the only way to guarantee we avoid probate. We're going to define probate. We're going to talk about that a little more in the slides, but I just want to give a little bit of a preview there. So again, the idea is that if those assets exceed 50 grand, we need to have a trust. So again, the good news is, with this slide, is that a lot of people, again, maybe not in this room, because this is a bit of a self-selected room, but if you, again, go to Walmart, poll 100 people, statistically speaking, about 90% of them would not have estate plans. 90% of American adults do not have an estate plan. Now again, that includes people who just turned 18. The issue is this. Under Wisconsin law, if you die without an estate plan, the state of Wisconsin creates one for you. That does not mean the state of Wisconsin gets everything, which is good. It just means that the state determines who gets it. And they do so through a document called a table of consanguinity. In English, it's a family tree, okay? Whomever your next of kin would be, that's who would receive it. The problem is that may not be who you want to receive it. Powers of attorney terminate on divorce. This is important, okay? I have a lot of clients who, I mean, let's face it, 53% of marriages end in divorce, right? So the logic there is that more often than not, if I meet with a random couple, they're eventually going to get divorced. So it's important to know that the good news is that if you have existing estate planning documents that nominate your spouse and you end up getting divorced, under Wisconsin law, that spouse is deemed to have predeceased you, because most people, though there are exceptions, I've run into this in my practice, most people do not want an ex-spouse making medical or financial decisions for them. Okay, pretty straightforward there, right? So again, good news is that that terminates, but again, we may want to have someone else ascend to that position to be able to make those decisions. All right, important one here. Outside of a judge, guardianship can only be established by an estate plan. Again, this is for the people in this room, again, based on demographics. I don't know how many people we have in this room who have children under the age of 18. But again, we have a lot of people who might have grandchildren under the age of 18, and that's the people who need to listen and be informed of this message, even if they're not physically here today. The only way to determine guardianship under Wisconsin law, if both parents pass away, is through a will or a trust. Literally nothing else works. I have clients who say, well, I have a notarized letter, I have a videotape statement, I put a video on TikTok. None of it matters. Okay? Again, the only way guardianship can be determined in Wisconsin is if we have a trust or a will. That's the only place it can be established. And again, most people who have children under the age of 18 are typically in their maybe 20s, 30s, 40s. That is a demographic that typically does not have estate planning documents because they think they're invincible. They think that they're going to live forever. And again, 100% mortality rate among the human race. That's a given, okay? So again, making sure that they are at least aware of the consequences of not having an estate plan, because if we don't have an estate plan, if we don't have guardianship established through either a will or a trust, the court is going to make guardianship determinations. And again, a court is going to do the best they can, but they're only given a snippet, a snapshot of what the information will be. Who better than the parents to decide who gets guardianship of the kids? And in my experience, maybe more importantly, who doesn't get guardianship of the minor kids, right? So again, has to be established through a will or a trust. Non-married individuals can create a trust. A trust, again, is just a document that allows for the disbursement of assets upon the death of the creator or the creators. You don't have to be married to create a trust jointly. Now, individuals can certainly create trust, but I've had siblings create trust for family land. I've had really good friends, people who've been dating for a long time or just haven't decided to get married. We'll talk about common law marriage in the next slide. Anybody can create a trust so long as you're over the age of 18 and of sound mind. So business partners, I mean, there's any number of reasons that people do it. I mean, I'd say 99% of my clients who create joint trusts are married couples, but you don't have to be. Common law marriage. I even had this question come up last week. I find it so fascinating how people are so misguided about common law marriage. There is no common law marriage. In fact, there has not been common law marriage in the state of Wisconsin since 1917. So if you are not married, you can't avail yourself to marital property rights. It does not matter how long you've been living with that person. It does not matter what the nature of the relationship was. It is either it's black and white. You are either married or you are not married. That is it. No common law marriage in Wisconsin. Adopted children are deemed included in an estate plan. Okay, this is really important. So I mentioned to you before the definition of per stirpes, which is along the bloodline. Well, technically adopted children are not along the bloodline. They are adopted. Wisconsin law says that legally adopted children, not adopted in name only, but adopted children are considered the equivalent of biological children for those purposes. So again, unless you affirmatively exclude the adopted children, they are deemed included. On the other hand, it's the opposite for stepchildren. Stepchildren are deemed excluded unless you affirmatively include them. And again, to be clear, when I say stepchildren, I mean step-grandchildren as well, because you may be in a situation where you have a child. We talked about per stirpes before. You say, I want my share to go to my child's children if they predecease me. Well, do we want to include step-grandchildren or not? I said it's a very personal choice. What I'm telling you is the default is adopted children are deemed included, stepchildren are deemed excluded. Again, age of receipt. This is important. I see a lot of estate planning documents that do not indicate an age. So the idea is this. Think about it conceptually, right? It makes no sense that if my wife and I die tomorrow, that my 15 and 13-year-old just get the money without any barriers or any limitations. It's absurd. To turn money over to a 15 to 13-year-old. That said, a lot of people don't necessarily want to turn it over to them the earliest they can possibly get it, which is 18. Most people want to see their children or grandchildren mature a little bit before they have access. The default is 21, okay? You can make it as high or as low as you want. For example, in my trust, my two boys do not get full access to the money until they are 30, okay? You can do it however you want to do it. Again, common theme I'm mentioning, there's no right or wrong answers in estate planning, okay? But the idea is making sure that we have it fit our preferences. But again, if the document is silent, it is deemed 21, okay? Again, in-laws cannot be completely eliminated in estate planning. I get this question all the time, okay? So the idea would be this, and this is the example I always use, and I apologize to previous seminar attendees because I probably used this example before. There's an idea, and again, when divorce rates are over 50%, it becomes even more of a heightened idea. How do I protect my child from a divorce if they receive inherited money? Okay, and the short answer is it's pretty difficult to do so. But let me just walk you through a hypothetical to kind of hopefully make this point a little bit clearer. Okay, let's say my parents, let's say I did anything else other than what I do for a living, because doing what I do for a living, I'm a little biased, of course, right? Let's say I did anything else for a living, and my parents decided to create an estate plan. They go to an attorney, create the estate plan, and they say, you know what? We are very concerned about Rob's wife. We really don't like Rob's wife. How do we make sure that if she divorces our beloved son, that she doesn't get anything, okay? And what the estate planning attorney is going to say, if he or she knows what he or she is doing, is going to say, you have to make, because we talked about inherited property before, being separate. What the estate planning attorney would say is, it's on Rob as the recipient. If Rob keeps that money separate, never uses a single penny of that for joint marital expenses, if they got divorced, it would be considered non-marital property, not subject to equitable distribution on divorce. That's the legal answer. Now I'm going to give you the practical answer. I attend that meeting. I hear that, gee, my parents are concerned about the divorce and I have to keep the money separate in order to preserve it so that my wife can't get it if she divorces me. I drive home that night. Of course, my wife asks, how'd the meeting with the lawyer go? My response, great. It was phenomenal. Here's what's going to happen. My parents are really concerned about you divorcing me. So when they die, I'm going to get that money. I'm going to keep it in a separate account. I'm not going to use a single penny of that for any joint marital expenses because I don't want you getting a dime of it if we get divorced. Here's my practical question. How do you think that conversation is going to go? I think your last answer that for me. That's exactly right. That's the problem. So again, we can do it, but the implications of that sometimes are difficult. Wills alone are never enough. Okay, this is where we kind of get into probate and different things like that. Okay. What I can tell you is this. If you are in group 2 and you just have a will-based plan, hopefully you have powers of attorney as well, because there is no will in the state of Wisconsin that gives authority to make decisions while someone is alive. So at a bare minimum, you need those financial and healthcare powers of attorney. But again, if you have a will and you have more than $50,000 worth of probate assets, the estate goes to probate. Okay. Most people have that in the equity in their home alone, let alone any other assets we get to. So again, if we have more than $50,000 worth of probate assets and you only have a will, the estate goes to probate. What is probate? A term I'm sure everyone in this room has heard before. One sentence definition. Probate is the process where a court oversees the administration of an estate. Probate is the process where a court oversees the administration of an estate. There are many reasons we want to avoid probate, and I'm going to go through them with you now. Fact one, probate is expensive. The average cost to probate an estate right now in the state of Wisconsin is between $8,000 to $12,000. Some are more, some are less. These costs can go up if there's family disagreements or if there's additional parcels of real estate. That's just an average. Reason number two we want to avoid probate. Probate is time consuming. Average length of probate in the state of Wisconsin is 12 to 18 months. Again, this allows for publication notices, tax filings. Again, 18 months is the default in Milwaukee County. As I'm sure you can all appreciate, Milwaukee County is on the slow end, okay? So the idea there is they don't even give that 12-month option. They default it to 18 months. A lot of probate cases take more than 18 months. I mean, I have a couple, full disclosure, I have probate cases, right? And usually how I get the probate cases is I do an estate plan for Betty. Betty's satisfied with the work that I do. Well, I get a call from Betty a couple years later. Betty says, hey, my brother died without a trust. We need to go to probate. So that's how I get the probate case in. Because again, if we create a trust and we fund it properly, it's not going to probate, okay? But my probate case, I had one probate case last 4 years. We had out-of-state property. We had siblings fighting with each other. There's any number of reasons why it can take significantly more than 18 months. And the remedy is simple. Just create a trust. You avoid the whole thing. So to recap, probate's expensive. Average cost is about 8 to 12 grand. It's time consuming, takes about 12 to 18 months. And the final big reason is that it is public record. Okay? When an estate goes to probate, the will becomes public record. Not only does the will become public record, the amount and the character of the assets also become public record. Let me explain that concept, okay? Again, there's a lot of familiar faces in here, but there's a lot of people I don't believe I've ever met before, okay? I have no problem telling you that if I had a will, what the distribution pattern would be. Everything to my wife, if she survives me, if she doesn't, divide it evenly between my two sons once they reach the age of 30. I have no problem sharing that with strangers or people I hardly know or people I've met a couple times. The problem, though, is that's not all that becomes public record if it goes through probate. The value of the assets, the type of assets that I had at death also become public record. And no offense, I don't feel comfortable sharing that with really anybody except for my folks in the back who work with me at Client First with my accounting and taxes. That's it. Those are the only people who I want to be privy to that information. But when it goes through probate, it does become public record. Fact 32, estate planning is not set it and forget it. I have so many people who I meet with. Once they create the estate plan, they just go, I'm glad it was done. You made it easy, but I'm glad it's done. And my response to them is, yes, it's done for now. But life events could occur that would cause you to want to change and update the documents. And that's very important because I challenge anybody in this room to look back 20 years ago and tell me if A, you'd want the same people making those decisions as you did back then, and B, if none of the information of those people has changed. No phone number changes, no address changes, no name changes, anything like that. Or even 20 years from now. The point is life happens. And we need to be able to update the documents. And again, not only can you update those documents at my firm, because they're all revocable, all have the ability to be changed, but I do so at no charge. If you create your trust-based plan with me, I offer complimentary revisions for life. Out-of-state trusts and wills are generally unenforceable in Wisconsin, okay? I had mentioned that when it comes to establishing residency, Wisconsin typically does not honor out-of-state trusts. The opposite is typically true. Wisconsin trusts can be honored out-of-state, but again, Wisconsin also has some pretty insular things. Because again, in many cases, if they apply state law, then they are considered to be state-specific. So I see a lot of out-of-state trusts that reference state statutes that simply aren't applicable here in Wisconsin. So the process I go through, I made up a word, not Shakespeare, but I made up a word, Wisconsinize. I Wisconsinize out-of-state estate plans. Financial powers of attorney can be either immediate or spring. This is a very important one because I see this all the time, all right? The idea is this. Immediate's obvious. The moment a financial power of attorney is signed, that person has authority. Springing, on the other hand, means that the document only goes into effect after two physicians or a physician and psychologist have personally examined the individual and they conclude that they lack the ability to receive and process information. Okay? That's a mouthful. Let me give you a visual demonstration that I think makes this point a little clearer. Let's say where my right hand is represents legal capacity. If you're above this point, you have capacity. If you're below this point, you don't. We're all here right now. Maybe we're here, but we're all pretty much here. Okay? Most people, barring a catastrophic accident or an incredibly quick onset of a disease, don't do this, right? They do this. And the problem I get to in my practice, I get a lot of my clients who are right here. If the financial power of attorney is springing, their loved ones can't do anything for them while they're here because they're still above this threshold, okay? They can only act if they're here or worse. So that's why I am a fan of immediate financial powers of attorney, because again, you get to pick whomever you want over the age of 18. Presumably, you trust that person to not misuse your money. So again, if you have existing documents that I did not draft, it's important to find out with your attorney, or I'll even review them for you at no charge, whether it is immediate or springing. Let's talk about pets for a little bit, okay? Again, I know there's a lot of pet lovers in this room. All right, what I will say is this: I wish I was a pet lover, but I'm allergic to pretty much every cat and dog I've ever encountered in my life. Okay, so I apologize for that, but I can deal with them from an estate planning standpoint from a distance. Okay, under Wisconsin law, pets are considered personal property. They're no different than the grandfather clock or the Persian rug. Okay, but there are important things that come with pets in terms of who's going to care for them. So I do recommend that people put provisions in their estate plan not only for who's going to get Fido or Rex, but just say any pets in general, because Fido and Rex may predecease you, okay? And you may get another dog down the road or another cat down the road. It's also important to make sure that we leave funds for that cat or dog's care. You know, the idea is this: if you're going to place the dog or cat with a family member or a family friend, the courteous thing to do would be to leave them some money for that pet's care, okay? And depending on the nature of the animal, that would dictate how much you feed. You don't feed a Great Dane as much as you feed a Great Dane a lot more than you feed a Chihuahua, right? I mean, you got to know what these animals are going to incur. If a dog is sickly and whatever the case is, it's not legally required, but it is the courteous thing to do, in my opinion, to leave them funds for the care of those animals. And the other thing is, if you have any, for lack of a better word, exotic animals or non-traditional animals, I guess might be a more euphemistic way of saying it. I had a client who had 4 horses. Well, you need to have land for horses, right? You need to be cognizant of where those animals are going to go. You know, snakes, things like that. Not everyone's equipped to handle snakes. So making sure you're aware of that when you create your estate plan, okay? 36, life insurance is not a substitute for funeral trust planning. I run into this all the time, and I bet I could almost guarantee you that among the many clients I have in this room, I'm not going to call anybody out, that one of you has said the following to me: I have a life insurance policy. The purpose of that life insurance policy is to pay for my funeral. I hear that all the time. Enough to put me in the ground. That's the phrase I hear a lot, okay? Here's the problem. It's not going to go that way if you need governmental assistance to pay for your nursing home care. The government will require you to liquidate that life insurance policy regardless of what your intent was for that money. The only way that can be protected is through a funeral trust. I love funeral trusts. Now, the only problem that I have with funeral trusts is that they're called trusts, because my clients mistakenly believe that I, as the attorney, can create those trusts. I can't. It is essentially a prepaid life insurance policy that allows you to set aside up to $15,000 for funeral expenses, and that money is protected from nursing home estate recovery. So there's a lot of benefit to doing that. I am certainly able to talk to anybody after this meeting if they want more specific information about funeral trust planning. Okay? Again, there are services that help with the placement of the elderly. Okay? I know a lot of you attended a lot of seminars. I don't know if you remember when I co-presented with Iva. You guys remember Iva? Okay. Iva's wonderful. I had lunch with her yesterday just by coincidence. She helps people with placement because, again, it's overwhelming. Where do we go? What kind of facilities do we go? Iva will, and she has a lot of experience in terms of placing people at the facility based upon preferences, based upon geography, based upon religious preferences, whatever your goals are in a facility, the level of care they provide. And the best part about her services is she does not charge a dime for her services, okay? She gets paid by facilities that she places people into. So again, if anybody's interested in that, I can certainly give you Iva's phone number. I know it off the top of my head because I give it out a lot. So that's what I want to mention there, okay? Importance of family meetings. Again, I'm sure everyone in this room, if not through any other medium but television or movies, have heard of this doctrine of the attorney-client privilege, okay? Attorney-client privilege is something I take very seriously as an attorney. I need to have my clients feel comfortable in sharing information with me, because if I don't have full information, I can't do my job. So there is that attorney-client privilege. I am not allowed to break that privilege for any reason without the consent. That said, without consent. I encourage my clients to break the attorney-client privilege in terms of getting together with family and having family know about the plans. It's not required at all, but to the extent that people want their children or other loved ones involved, I encourage that for a couple of reasons. One is transparency. Two is because, with all due respect, more than likely, I and those people are going to outlive you. And if I or those people outlive you, it's important that they know how this plan is set up, who's doing it, what the issues are. And this is especially important when we have disparate treatment. I'll give you an example of that. I had a client, he was a widower. He decided to leave 60% of his estate to his daughter and 40% to his son. And I'm just the attorney. I put it down. He probably said, you're probably curious why I did that. I said, well, yeah, as a human being, I'm curious. But as a lawyer, it doesn't matter to me. I'll put down whatever you want. And what he said was, daughter ended up getting a 4-year full ride scholarship to college. Son ended up going to a private college that dad paid for. His thought process was, I gave son more during life. I want to give daughter more at death. I'm not here to judge right or wrong, but what I did tell him is, I said, you may want to have a meeting with your family to talk about that. Because if you die and they see this trust that I drafted go 60-40, son may be wondering, what did I do wrong? Where did I screw up? And he'll know that it wasn't a screw up. It was just, this is what dad thought was the right thing to do. So again, I encourage those family meetings all the time, but particularly where there's a disparate treatment, okay? Real estate cannot be sold or transferred in the name of a deceased person, okay? That's probably common sense, but a lot of times what will happen is you'll have a married couple and one spouse dies, and then the surviving spouse wants to downsize. They want to move closer to a hospital. They want to move in with a kid, and they try to sell the home. Cannot be done in the name of a deceased spouse. You go to an attorney of your choosing. It's very easy to file a 2-page document with the court to remove deceased spouse. Pretty straightforward. Documents get lost. Happens all the time. I get that call frequently about clients losing their estate planning documents. The good news is at my firm, I keep a copy of every single one of my clients' estate plans. And it's easy for me, being a millennial, I have a cloud-based system that does that. If I was 20 years older, it would be a lot more difficult because I'd have boxes on boxes on boxes of documents. Probably wouldn't hold on to every single one. But at our firm, it's very easy. Shannon, one of my paralegals, is in the back. We coordinate that all and make sure that all of our clients' documents are saved to the cloud. Making sure children can have access to safes and lockboxes. I can't tell you how many times I get calls from clients saying, hey, mom and dad died, what's the combination of the safe? I have no idea. I've been practicing law 18 years. I've never once received a key to a client's safe. I've never once received a combination of a client's safe. Same thing with safety deposit boxes. Those safety deposit boxes, there's nothing I can do as a lawyer on those. It is a lease that when you have a safety deposit box, you have a lease with that bank that says, here are the circumstances in terms of who can get them. So again, anyone who has the safety deposit box in the audience, I encourage them to talk to your banks and find out how that can be accessed. 42, again, they can be tricky, same thing. I just mentioned this, they're leases. I skipped ahead of myself here. So again, talk to your banks, make sure the kids can access it. Fact 43. Again, at my firm, I can only speak for my firm. What I've heard from a lot of people who come to me after meeting with several attorneys is they say, my goodness, you simplified the whole process. Again, a lot of attorneys have very complicated intake forms that require you to list every single asset you own, the amount, all of that. I don't do that at my firm. I just get to the point, make sure we get assets in the right place. I need to know the nature of the asset, but I don't need to know the value of the asset. Again, having that conversation takes no more than 10 to 15 minutes. Attorney-client privilege, again, we talked about that in the context of family meetings, but the importance there is to encourage free communication with the attorney. If I don't know something, I can't plan for something. It can be waived by the client. Again, we talked about with family, but also with client first, with tax professionals, insurance agents. Client first offers all of that. Waiving that attorney-client privilege in that group is very important so that we can communicate, because we're all on the same team, making sure that everything goes smoothly there, okay? Attorneys are licensed by state. I mentioned that before. I'm only licensed in Wisconsin. I'm technically retired in Pennsylvania, but basically only in Wisconsin. Now, attorneys can be licensed in multiple states. In other words, if I was in Kenosha, I'd probably have a Wisconsin and Illinois license because I'm so close to Illinois. But right where I'm at now, no sense. I'm just licensed in Wisconsin. Transfer by affidavit forms for small estates. If the estate does in fact have less than $50,000 worth of probate assets, we can avoid probate through a small estate affidavit. And that happens frequently. Matter of fact, there's people in this room I've done those for relatives. Very quick, very easy process. But if we're under $50,000, it's the only way we can do it. Estate plans have no expiration date. It's not like a gallon of milk where we know after a certain date it's bad. So just because an estate plan is old does not make it unenforceable. But the older it is, the more likely the A, laws have changed, or B, preferences have changed. So if you have an old estate plan, it's a good idea to get it reviewed by an estate planning attorney of your choosing. 49, we talked about this earlier. Charities, charitable distributions should oftentimes not be completed through the trust. We should rely on beneficiary designations of retirement accounts. Why? Because if a human being receives an inheritance from an IRA, they're paying tax on it. If the charity is receiving it because they're a charity, they're not. So again, if you have charitable intent, it's important to make sure that we understand that the ability to provide for that charity is usually best accomplished outside the trust. Fact 50, a very easy one here. I'm always available to answer questions. Whether you're an existing client of mine, whether you're not a client of mine, if you're a client of Client First, you can always call my office, basic questions. I don't charge for advice because advice gives us more knowledge, but it doesn't move the ball. The only way it moves the ball is if we implement that advice. So again, I'm always happy to hear from existing clients, but I'm equally happy to hear from people who have not yet retained my services and who have some existing questions. Okay? So, yeah, that's 50 fast facts. So I appreciate your time here today, and I do have a little bit of time for questions here. I thank you for the opportunity. Have a great day. Any questions? Yes, ma'am.
How often should your estate plan be reviewed?
How often should your estate plan be reviewed? I recommend that my clients review it amongst themselves about once every 2 or every 3 years. And if there are questions, you can always contact your attorney. Any other questions? Wow. Yes.
Not a question, just a statement. I took my trust to the banks to be put on the accounts.
Yes.
I spot checked, that was about 4 or 5 years ago, I spot checked just recently, found that they had put the trust on only one of my multiple accounts.
Yes.
So I had to go back and redo it again. So just that word to wise, just because you go there and say, I want this on my account, doesn't mean they're gonna do what they're supposed to do all in one.
Absolutely. No, that's very good advice. You got to make sure the banks do what they say they're going to do. Absolutely. Any other questions? All right. Well, I will be available in the back if there's any subsequent questions. Otherwise, thank you for the opportunity, Client First, and have a great day.
All right, thank you, Rob. Just a couple notes here. You know, at Client First, we make financial planning make sense. So we invite you, if you haven't already, to schedule a no-fee consultation. I'll be happy to help you from there. There's also a survey that you probably received as you walked in, so if you could please take a moment to fill that out. You can leave it on the table, or actually I think if you're bringing it in the back, that'll help us out a little bit. But other than that, we thank you again for coming and hope you enjoy the rest of your day.